All right, good afternoon. This is our fourth round of our competition that we're calling the Coronavirus Cancellations Moot Court Competition. For those of you who have not watched any of our earlier live streams, let me give you a quick rundown of what's going on here. We have two of our competition teams in our moot court program who were preparing for their oral arguments, but had those oral arguments canceled, unfortunately, because of the COVID-19 pandemic. And so what we are doing is having this sort of mini competition in which the two teams are making arguments to the same sets of judges, and we will be scoring them based on their arguments and awarding a best team and a best oralist and so forth. We're also using this as an opportunity to have a demonstration for students who are in the Lowering Skills program about to do their oral arguments, and as well as some prospective students may be turning in as well. A moot court competition consists of two parts: a brief that you write on a hypothetical problem. It is usually a hypothetical Supreme Court brief, and you receive a score on your brief. And then you also participate in an oral argument competition, usually 2 or 3 preliminary rounds where you argue both sides of the issues. After that, advancing teams are identified that go on to engage in an elimination tournament that's very similar to something like the NCAA Sweet 16 basketball tournament. You have octafinal, semifinal, quarterfinal, semifinals, and then you finally are named a champion in the particular competition. It's that part of the competition that we're trying to replicate today through the arguments that you're about to hear. There are 4 advocates. Each of them will be arguing for about 14 or 15 minutes, each of them on one side or the other of one of 2 issues in their hypothetical problem. At the end, the petitioner will have an opportunity to do a short rebuttal in which they reserve some of their time in order to take up some of the points made by the respondent party. We have 2 judges with us today, and I'm going to allow the moot court board members who are moderating the chat to introduce the judges for you. And are about to formally begin the session as the bailiff for this particular round. The bailiff is the person who lets people know when it's their turn to talk and so forth. I will be doing time cards, which you will not see, but the people making the arguments and the judges will see them. The time cards are at 5 minutes, 2 minutes, 1 minute, and then I will put up a stop sign, at which point the advocate is supposed to acknowledge their time is up and ask the court to conclude. So with that in mind, I'm about to do the formal introduction of the court, and then I will turn it over to our chief judge for today. Oyez, oyez, oyez. All those having business before this honorable court draw near and shall be heard. The Honorable Judges Sarah Taylor and Chief Justice David Herndon presiding. God save the United States and this honorable court.
Thank you, and good afternoon, everyone. We have called for our consideration the case of United States ex rel. Simpson versus Specialty Pharmacy et al. So we'll look to the petitioner for argument, and if first counsel would approach the bench and favor us with an argument. Thank you.
Thank you, Your Honor. Chief Justice, Justices, may it please the court. My name is Christina Cook, and I, along with my co-counsel, Megan Fugate, represent the petitioner in this case, Specialty Pharmacy. At this point in time, Your Honor, the petitioner requests 2 minutes be reserved for rebuttal.
Sure.
Thank you, Your Honor. In my co-counsel's time before the court, she will establish that the respondent's claims fail to satisfy the causal connection requirement of the AKS, nor does it establish a violation of the FCA. In my time before the court, I will establish both that the one-purpose test should not be adopted due to the fact that it is overly broad, and that the primary purpose is better suited in evaluating anti-kickback claims. Your Honor, this case is about a pharmaceutical company donating to a nonprofit and an individual, assuming that that company must be acting in bad faith. This case here today will essentially determine the viability of charities in the future and the way they interact with their donors, and their ability to to provide life-saving medication for low-income individuals that may have no other way of receiving the medication they desperately need. As to my first point, the one purpose test should not be adopted due to the fact that it is overly broad. Under the AKS, there is only a violation when an individual or business knowingly and willfully solicits, offers, receives any kickback or bribe in connection with furnishing of Medicaid or Medicare services, or referring a patient to a provider of those services. However, the respondent fails to demonstrate that SP knowingly and willfully paid any remunerations with the intention of gaining referrals. This court chose, if this court chose to adopt the one purpose test, it would substantially hinder charities' abilities in order to utilize aggressive fundraising tactics, such as DUF. DUF chose to utilize its fundamental right of advocating for increased donations, which is protected under the First Amendment. Recent case law suggests that widely distributed information and generalized promotion of a healthcare provider does not run afoul of the AKS. In the Village of Schaumburg versus Citizens for a Better Environment, this court stated that charitable appeals for funds on streets or door to door involve a variety of speech interests and the advocacy of causes, and are therefore protected under the First Amendment. This court furthered that holding again in United States versus Riley, in which this court struck down a portion of regulations which encourage fundraisers to cease engaging in certain types of fundraising, such as solicitation combined with advocacy, as we have here today, because that would restrict charities' abilities to speak.
Isn't this purely, counsel, isn't this purely a case where donations were made to obtain referrals that would benefit SP, your client? Isn't that what happened here?
No, Your Honor, that is not what happened here today. There is the respondent cannot point to a single piece of evidence that demonstrates that factor, but rather is simply assuming that they are made in bad faith.
What about the cost benefit analysis that you pursued in this case?
Yes, Your Honor, there was a cost benefit analysis done. However, that was in response to 100 letters that SP received after DUF had sent out their own letter advocating for more donations. And that is when SP realized the economic impact that reducing their charitable donations would have on the community. And SP reversed their decision and donated the same amount it had been since 2012. And the respondent cannot point to a single piece of evidence that proves that any of the 24 patient examples they published to the court had anything to do with SP being placed on DUF's supposed list. They cannot show that any individual received the list or even that they knew about DUF's preferred vendor list in the first place.
Wasn't the purpose of specialty after getting the cost benefit analysis to recognize that the benefit to them was a profit?
Not necessarily, Your Honor. It does not demonstrate in the record that it says anything about whether or not they would lose money or gain money, or simply they could have just simply remained the same. That is not demonstrated in the record. It simply states that they did the cost analysis and then they made the decision to increase their donation. Therefore, if this court chose to utilize the one purpose test in order to determine whether or not SP acted knowingly and willfully, it would unconstitutionally impose a limit as to how charities could communicate with their donors or advocate for future donations.
But isn't what you're asking us to do following the primary purpose test would allow for kickbacks, basically, which is kind of the opposite of the anti-kickback statute. It would allow for kickbacks as long as that's not the primary purpose of the donation. So how does that further the anti-kickback statute's purpose?
Because, Your Honor, the purpose of the statute was in order to stop fraudulent practices. It was not in order to allow all possible or all claims to be considered violations. The Office of the Inspector General of Health and Human Services asserted that there were ways that businesses could use patient assistance programs without violating the AKS, so long as there are certain conditions that were met, demonstrating that Congress did not intend for a broad catch-all statute such as the one-purpose test, but rather they only wanted to find violations when there were certain conditions met. And if you were to apply the one-purpose test, essentially what it would mean is that if 99% of your donation was made in bad faith, and somewhere in the back of your mind, 1% said, hey, maybe I will possibly get referrals for being charitable, then because that 1% was in the back of your mind, there is automatically a violation, thus causing a chilling effect.
So here, the implication, if not more than a simple implication, is that your client knew that when the donations were made, that those donations would be used to purchase your client's product.
No, Your Honor. SP had no knowledge whether or not it would be used to purchase their product. SP was simply a name on a list along with 4 other organizations. And on that list, it stated that SP was one of many that maintained the highest quality of care and products while providing services, constantly supporting the community in various ways. And as part of this recognition, Duff was showing that they had a high esteem for SP along with the 4 other corporations on that list. And that is why they included them as providers. However, simply because they are providers, the patients are not required to go to SP or any of the other organizations on that list. They still maintain the right to visit any organization that they feel they will get the care that they deserve. And it nowhere in the record does it state that because SP was possibly going to lower their donations, and if they had chose to lower their donations, would they be taken off that list anyways? They may have still remained on that list even if they chose to decrease their donations, demonstrating that this was not a relationship that was untoward, but rather a business transaction where SP and Duff were simply having a donor-donee relationship.
So if the people who were receiving Medicaid or Medicare, if they had gone to a vendor who was not on, or a provider who was not on Duff's list, would they still have gotten reimbursed by Duff for their copays and that kind of thing?
Yes, Your Honor. They still would. That money would be to Duff's patients specifically, and then they make the decision where they will go from there. So despite where they chose to receive that care, it would not change whether or not they would receive the money from the donation.
Okay, and that's in the record?
I'm sorry, Your Honor?
That's in the record?
No, Your Honor, it does not state in the record that they would no longer receive the care, but simply that the donations were made to Duff and then Duff distributed the donations. So it does not matter where they would go, they would distribute the donations prior to receiving the care. Also, Your Honor, simply being a name on the list should not stop donors from being able to donate. And respondent contends on page 2 of the record that during his role as vice president of SP, he believed there may be possible fraudulent practices, but that was back in 2005. And he chose not to file against SP until 2017, which he now has a chance of gaining upwards of $30 million. Demonstrating that respondents lack in credibility, because if he had brought the suit in 2005 when he believed the fraudulent practices began, the case would have been dismissed due to lack of evidence demonstrated by the record. Therefore, if we apply the one-purpose test and have such a broad statute, it will lead to inconsistencies, such as the respondent in this case being able to wait years for an innocent situation such as we have here, that they could possibly twist into a possible violation, opening the floodgates and leading to an increase of frivolous lawsuits filing in the court, which will be a waste on court's resources.
Well, you're asking us to find summary judgment here. So why is summary judgment appropriate here? Why should this case not be presented to a jury so they can make a determination?
Summary judgment is appropriate here because all material in the record demonstrates that there is no genuine issue of material fact, and therefore SP is entitled to summary judgment as a matter of law. If this case were to continue, it would be a waste on court's resources, and it will likely and there is no other evidence that Realtor can offer, especially considering he moved for summary judgment himself, and he has already amended his complaint once. Therefore, if there was more information, it is likely that it has already been included in the record here today. And although the First Circuit is the only circuit to adopt the primary purpose test, other circuits have also started to increase their standards for AKS violations. The 10th Circuit did this in United States versus McClancy, where it increased its burden to require the plaintiff to prove beyond a reasonable doubt that the defendant acted knowingly and voluntarily with specific intent to offer or pay remunerations to induce referrals. Under both of these heightened standards, there would be no AKS violation because the respondent cannot point to a single piece of evidence that the donations were made in bad faith, but rather they are simply just assumptions.
Do you think that the standard should be that without evidence of a confession, so to speak, absolute acknowledgement that it was a kickback situation without consideration of circumstantial evidence? Is that the standard you're looking for?
No, Your Honor, that is not necessarily the standard we're looking for. We're not asking for there to automatically always be a violation. There does not need to be direct quotes from people saying that this was a kickback. However, there does have to be a heightened standard. The one purpose test is so broad that it becomes an unworkable standard. And essentially, every suit that is filed underneath the one purpose test automatically is a violation if there is any sort of circumstantial evidence. Because as I mentioned, all it takes is that 1%. So even if it's in the back of your mind, it's still considered a violation. And I see my time has expired, Your Honor.
Thank you. Thank you, counsel.
Thank you.
If your co-counsel could offer argument, I'd appreciate it.
Thank you.
Sure.
Chief Justices, may it please the court. My name is Megan Fugate, and I too represent the petitioners in this case, Specialty Pharmacy, a pharmaceutical company that services type 1 diabetics. In my time before the court, I will establish that the 15th Circuit erred by reversing the district court's decision in favor of SP for two main reasons. First, Realtor's identification of claims involving payment for SP's goods and services do not satisfy the causal connection requirement of the anti-kickback statute because Realtor has failed to show any link between SP's donations to Duff and the 24 patient examples.
So what about that cost benefit analysis that was performed? The purpose of that, at least arguably, seems to be relative to a profit motive. And in other words, I kick back $1, I get $5 in return.
Your Honor, the motive of SP should be analyzed under the primary purpose test, as my co-counsel explained, in order to determine whether or not there is an AKS violation. However, the causal connection requirement of the anti-kickback statute demands there be a link between these so-called payments to Duff and the alleged kickback from the government for the referral of federal patients.
So my point is, isn't that a dispute of material fact? That very connection that you say doesn't exist? I don't How is that a matter of law as opposed to a factual matter to be determined by a jury?
Your Honor, the letter is not disputed. It is reflected in the record that Duff wrote this letter to SP threatening them that if they did not restore their donation, that they will no longer have them is a part that they might not want to do business with them. However, that does not seal the deal. That is not a smoking gun. And the relator in this case even concedes that there is no dispute of material fact. As my co-counsel stated, he himself has moved for summary judgment. Instead, this is a question of law for this court to determine what is the standard under Congress's amendment of the AKS in 2010. And I will address that in my first issue. And as far as my second issue, relator has not established that SP acted knowingly and has not provided any evidence that any claim for payment was false as required under the False Claims Act. So to speak further into Your Honor's question in regard to my first point, the relator's claims in this case do not satisfy the causal connection requirement of the AKS. Judge Homer of the 15th Circuit said it best in his dissent that to find an AKS or an FCA violation in this case would be nothing short of trying to fit a square peg into a round hole. So the Congress amended the AKS in 2010, specifically section 1320A-7BG, to state that a claim that includes items and services resulting from a violation of the AKS constitutes a false or fraudulent claim for purposes under the FCA. The keywords resulting from establish the causal connection requirement. And while this court nor Congress has defined the resulting from requirement in the AKS, this court has held in Burrage versus United States that where death or serious bodily injury results from the use of a controlled substance, that the government must prove that the controlled substance was the but-for cause of death. And the federal circuits have relied on this court's interpretation of the resulting from language in cases that involve violations of the AKS. For example, the Fifth Circuit in King versus Solvay Pharmaceuticals held that the relator's suit was properly dismissed through summary judgment because the relator had failed to allege that the kickback scheme was the but-for cause submission of any false claims. Further, the Seventh Circuit in United States versus Luce recently held that where the relator had failed to establish a link between the alleged kickback and the payment of federal funds did not establish an AKS violation because this court held in Universal Services versus Escobar that all common law fraud principles apply in FCA cases, including causation. And so a relator in an FCA lawsuit must prove that the defendant's alleged misrepresentations were the but-for cause of the government's damages. And while petitioner suggests that the but-for test is the most appropriate test that is consistent with Congress's intent in this amendment, alternatively, if this court does not want to adopt a but-for requirement of causation under the AKS, then this court should still require that a relator show a link between the AKS violation and the reimbursement claims, as the Third Circuit recently held in Greenfield versus Medco Health Solutions.
So, counsel, are you disagreeing then that the facts on the record show a quid pro quo relationship, that your client makes a donation to Duff and Duff provides them patients referrals?
Yes, Your Honor. While respondent will argue that this was a quid pro quo arrangement, in reality, this was nothing more than a donor relationship, as my co-counsel had pointed out. SP does make a lot, and SP's goal in their donations to Duff is just to give back to the community, is reflected in the record. Duff is a non-for-profit organization that simply helps assist in paying the copays of type 1 diabetics to help them get their medication, and also is reflected.
But what about the fact that Duff sent this when they believed they were going to get less of a donation from your client? They sent a letter out to all these patients basically saying, if you don't contact SP, you're going to lose your benefit from us. You're going to lose our contribution to your payment of your copays. And then shortly after learning about the letter, your client decided that they were going to go back to their original level of donation. I mean, doesn't that strongly suggest some kind of a quid pro quo situation?
No, Your Honor. Just the letter was a reflection of panic, as they had thought that they would not get enough funding, and they could have went about the situation in a more appropriate way instead of sending out all these letters. However, that was not the case, and as described in the record, Duff is a pit bull. They call it for donations, and so they were simply advocating for SP to restore their donations, which SP eventually did. However, that does not evidence a quid pro quo arrangement. Instead, something that might.
That's your position, but isn't that really a factual determination?
No, Your Honor. The facts in the record are undisputed, as both parties have moved for summary judgment. However, this is a question of law. This is what will this court require under the AKS and the causal connection requirement. Should this court require something so attenuated, as respondents will argue, that they cannot even point to one single false claim that was submitted, and they cannot provide evidence as to any link between the alleged 24 beneficiaries and SP's donations to Duff? Or will this court require a but-for causality, as this court has required in the past? Or will this court require a direct link, as recently required by the Third Circuit in Greenfield? Specifically, the Third Circuit held in Greenfield that a relator must provide some evidence that shows a link between the alleged kickbacks and the medical care received by at least one of the federally insured patients. Something that a relator could do that might get us a little closer to an actual case that might need to proceed to trial would be maybe a case if SP was the only listed provider on Duff's website saying to his patients, hey, go to SP, or something that clearly showed this quid pro quo arrangement. Instead, all respondent does is bring forth circumstantial evidence, and they themselves think that summary judgment is appropriate in their favor, despite.
Let me stop you right there. Are you under the impression that just because both sides in a litigation move for summary judgment, that therefore the court must grant it for one side or the other?
No, Your Honor. Respondent will argue that in the alternative, if this court does not find summary judgment appropriate for their case, that they should go to trial. However, that should not be ordered in this case, because this court should set a clear standard for the AKS causation requirement. And
You think that's the but for?
Yes, Your Honor. Or alternatively, at least.
You don't think a but for determination is a factual determination?
Your Honor, all of the facts are disclosed in this case. There are no additional facts that the relator can bring forth if this court were to order this case to go to trial.
But isn't a factual determination the fact finder's interpretation of those facts and what that means vis-a-vis the result in the case?
Yes, Your Honor. But even though the judge or a jury is the ultimate fact finder in a case here, both parties have moved for summary judgment because they think that their facts are pled and that they meet those facts. However, that is not the case. Mr. Simpson amended his complaint in the middle of the litigation, and he pulled forth 24 patient examples to try to plead a plausible cause of action under the AKS and the FCA. But as we see, he has failed because he cannot meet the causal connection requirement, nor can the relator establish that SP violated the FCA. As to my second point, a healthcare provider violates the FCA 31 USC section 3729 only when it knowingly submits false or fraudulent claims for payment or approval. And here, the relator fails to establish that SP acted knowingly in that they submitted claims that were false.
So if we were to find that there was a quid pro quo relationship, then would your client have violated the AKS by signing the paperwork?
No, Your Honor. I would like to answer your question in two parts. First, the petitioners, you do not believe that you could find an AKS violation under the primary purpose test because the relator in this case cannot prove that it was SP's primary purpose to induce referrals from Duff. But even under the one purpose test, the relator still fails to prove that there was an AKS violation. And even assuming that he could prove an AKS violation, which the facts of this case do not allow, but the relator still cannot prove an FCA violation, and that is because he cannot point to one single false claim that SP submitted. Specifically, as the record reflects, relator points to 915 invoices over the course of 5 years that SP has donated to Duff and alleges that all of the claims are false, thereby entitling, if this court were to find that it was a violation of the FCA, it would entitle the government to recover $90 million. It's 3 times the amount of the damages alleged, which would also entitle him to recover upwards of $30 million. And so the relator's motivations are relevant in this case when he stands to gain so much in return. And that is why this court must require a more direct link under the causation requirement and must require evidence of at least one false claim in order to prove an FCA violation. Last year alone,
You seem to imply that a false claim means, for example, say they sold something when they actually didn't, say they received something when they actually didn't. But doesn't the falseness of the claim go also to whether or not there's been compliance with things such as the anti-kickback statute, other healthcare laws on the books?
Yes, Your Honor, that's exactly what respondent will argue in this case, is that SP certified compliance on their forms each and every time they submitted a claim, and that is why they are false. But they're going to argue that one false claim taints the whole batch, which is not the case, and it should not be the precedent that this court should set. And therefore, this court should reverse the decision in favor of SP. Thank you.
Thank you. So first counsel for the respondent.
Thank you, Your Honor.
You're welcome.
Chief Justice, Justices, may it please the court. My name is Connor Londrigan, and along with co-counsel Logan Wallace, represent the relator, Mr. Bart Simpson, in the matter before you today. In my time before the court, I will explain why this court should affirm the decision of the 15th Circuit and grant summary judgment for the relator. A special pharmacy knowingly and willfully violated the anti-kickback statute by using donations to Duff to induce referrals. In co-counsel's time before the court, he will explain how SP violated the False Claims Act by submitting false claims for reimbursement of Medicare and Medicare claims that resulted from the anti-kickback statute violations.
So one quick question. Your opposing counsel say relator and you say relator, which is right?
I believe it is relator, Your Honor.
Yeah, so do I.
While this case may seem while the case before you today may seem like a relatively mundane instance of an inappropriate financial relationship existing between a pharmaceutical manufacturer and a charity, this case represents a much larger problem in the healthcare industry that has plagued the government since the inception of the modern healthcare sector. These secretive relationships have taken decision-making from the hands of individuals and their families, instead monetizing referrals that should be done with the purpose of healing a patient rather than trying to make a quick buck, and in turn, defrauding the taxpayers millions of dollars who are ultimately stuck paying the bill. The anti-kickback statute was originally enacted as part of the Social Security Amendments Act, making it a misdemeanor to solicit, offer, or receive any kickback or bribe in connection with furnishing Medicare or Medicaid services or referring a patient to a provider of those services. To be found in violation of the anti-kickback statute, an entity must knowingly and willfully solicit or receive any remuneration, including any kickback, bribe, or rebate, directly or indirectly, overtly or covertly. In an effort to determine what behavior constitutes the knowingly and willfully under the statute, a majority of circuits have adopted the one-purpose test. Here, the 15th Circuit correctly adopted the one-purpose test, as this test is the only approach that it supports Congress's intent behind enacting the anti-kickback statute. Special Pharmacy violated the anti-kickback statute in their quid pro quo arrangement with Duff, as SP knowingly and willfully offered remuneration in exchange for patient referrals from Dove.
Does that rise to the level of a determination as a matter of law?
We believe so, Your Honor. We believe that there is no material question of fact here, as SP clearly regarded these referrals as a benefit, as Your Honor suggested. By researching its return on investment, if diminished donations were maintained by SP, they acknowledged the fact that these referrals were a clear benefit, and as such that a quid pro quo relationship exists. SP's decision to restore funding is directly correlated to Duff's letters to patient treatment centers. And by identifying Duff's referrals as a return on investment, they acknowledge this. It's this very quid pro quo arrangement that has violated the anti-kickback statute and the kind of activity this court should seek to deter. Entities such as Duff must be stopped from defrauding the United States government and its tax-paying constituents. The Fifth Circuit in the United States versus Upton held that while a business cannot be held liable for knowingly or willfully committing an act because of mistake or accident, the business can be held liable for acting with specific intent to do something the law forbids. Although the anti-kickback statute does not define knowingly or willfully, the Model Penal Code defines knowingly as when the element involves the nature of his conduct or the attendant circumstances. He is aware that his conduct is of that nature or that such circumstances exist. Willfully is defined by the Model Penal Code as if a person acts knowingly with respect to the material elements of the offense. To determine whether certain behavior would qualify as being knowingly or willfully committed, most courts have adopted the one-purpose test, where if one purpose of the remuneration is to obtain money for the referral of services to induce further referrals, then a violation of the anti-kickback statute exists. The one-purpose test was created by the Third Circuit in the United States versus Greber, explaining that the language and purpose of the anti-kickback statute was to deter the growing problem of fraud and abuse in the healthcare system by increasing the severity of the offense from a misdemeanor to a felony. Under their interpretation of the statute, the court concluded that the anti-kickback statute text refers to any remuneration and is aimed at the inducement factor, not necessarily only the sums of actual services performed. In addition to the Third Circuit, this test has been widely accepted by a plurality of circuits, including the Fifth, Seventh, Ninth, and 10th Circuits.
Are there any that went the other way?
You're correct, Your Honor. There is one in particular, another that you could argue did. Alternatively, the First Circuit refused to accept the one-purpose test, instead creating the primary purpose test in the United States versus Bay State Ambulance Hospital rental service. By creating this test, the First Circuit determined that a payment constitutes a kickback under the anti-kickback statute if a primary purpose of the payment is to induce a referral or another payment reimbursable to under the federal healthcare program. Excuse me. Similarly, the 10th Circuit, while choosing to adopt the one-purpose test, decided to add a heightened burden in the United States versus McClatchy. The court found that it was necessary for the plaintiff to prove beyond a reasonable doubt that the defendant acted knowingly and voluntarily with the specific intent to offer or pay remuneration to induce referrals. However, if the court decides to adopt the primary purpose test or a heightened burden, it will place a substantial hardship on any prospective relator and the United States government. And
Does the
in fact, Congress
legislative
did not
history help us
intend in creating-
here?
I'm sorry,
Does
Your
the
Honor?
legislative history help us with a determination of which test we should adopt?
It could, Your Honor. However, the legislature did not speak clearly as to which test it thought should be adopted. That's a question the courts and more specifically the circuit courts have addressed and chosen predominantly to adopt the one-purpose test.
In
Is there-
those circuits that adopted the one-purpose test, was there reference to that legislative history?
Not specifically, Your Honor.
Is there evidence in the record, counsel, that the claims that your client brought forth and referenced, that those
I'm sorry, Your
specifically-
Honor, you cut out a little bit there. Could you please restate your question?
Yeah, can you hear me now?
Yes.
Stop moving, maybe that'll help. So the claims that you referenced, I think there were 24 of them that were made. Is there evidence in the record that all of those were made like on a quid pro quo basis? In other words, were all of them improper remuneration?
It's our position that each of those 24 were improper, Your Honor.
Okay, is
the
there
quid
anything in
pro-
the record that supports that?
Specifically tying those to a quid pro quo relationship? No, not specifically, Your Honor. However, the quid pro quo, or the existence of the quid pro quo relationship existing is essentially reflected in the record by the suggestion that from Duff that SP was acting in an untoward manner and enjoying the fruits of Duff's labor, while also acknowledging that SP in turn decided to conduct a return on investment, research return on investment, if they were to maintain their diminished donations to Duff. This
Okay, and
clearly
is that
reflects.
level of evidence? Because the petitioners call that circumstantial evidence that's not sufficient. So do you believe that that's sufficient for us to be able to find an improper relationship here?
I believe it is, Your Honor. I think that even in the event that you do treat it as circumstantial evidence, that is evidence that should be weighed and clearly has enough weight to suggest that this court should indeed grant summary judgment in favor of the relator.
So we could grant summary judgment when all we have to look at is circumstantial evidence?
We believe it's our position, Your Honor, that this evidence is not circumstantial. However, if this specific part of the evidence is viewed as circumstantial, we believe enough as a whole exists to support a grant of summary judgment in favor of the relator.
Is there
Further-
evidence in the record to the contrary?
I'm sorry, Your Honor, I'm not sure I understand your question.
So you think the circumstantial evidence is sufficient? Is there something in the record that suggests the opposite conclusion from that so-called circumstantial evidence?
It is our position that there is nothing in the record that opposing counsel could use to suggest that summary judgment should be granted in their favor.
And in your mind,
What
that's
about the fact-
that's how you can get to summary judgment with circumstantial evidence.
Correct.
What about the fact?
I'm
Oh,
sorry,
go ahead. Go ahead.
I just wanted to clarify, in the event that evidence is treated as circumstantial evidence. However, it is our position that evidence should not be treated as circumstantial. Thank you.
What about the fact that the petitioner argues that
I'm sorry, Your Honor,
Yes.
you cut out again.
what about the argument that the petitioner argues that there's no quid pro quo and you argue there is? Does that create a question of fact to prevent us from finding summary judgment for either one of you?
It's our position that there is no question of fact within the quid pro quo relationship, as opposing counsel fails to identify why SP would have chosen to research its return on investment had it not believed that its relationship with Duff derived benefit. By researching the return on investment of diminished donations, SP clearly acknowledges that it was a pay-for-play scheme, that they clearly derived benefit from the relationship. Otherwise, there would be no purpose to conduct this research. So it's our position that the quid pro quo relationship is more than evident, and that because opposing counsel fails to argue to the contrary, that summary judgment is appropriate in favor of the relator here, Your Honor. Further, the 15th Circuit correctly held that SP violated the anti-kickback statute because SP paid remuneration to Duff in order to induce referrals. SP is liable under the one-purpose test for 3 reasons. First, SP does not meet any of the necessary requirements under safe harbor exceptions. Secondly, that SP's behavior implicated the anti-kickback statute under the one-purpose test. And finally, that even under a heightened culpability standard, SP's actions still amounted to a violation of the anti-kickback statute. SP's arrangement with Duff does not constitute a safe harbor, as safe harbors were created by the Office of the Inspector General of Health and Human Services to provide specific regulations under which certain business relationships could exist and not run afoul of the anti-kickback statute. These safe harbor exemptions exempt certain kind of transactions from an anti-kickback statute liability, so long as these arrangements fit squarely into a safe harbor. If a transaction does not fit squarely into a safe harbor category, then it is possible that an anti-kickback statute violation must be assessed for AKS compliance on a case-by-case basis. But this is only applied in very specific scenarios. Safe harbors typically only include investments in large publicly held healthcare companies, investments in small healthcare joint ventures, space rental, equipment rental, personal services and management contracts, sales of retiring physicians' practices to other physicians, referral
Counsel-
services.
Council,
Sorry.
if we decide to use the one purpose test, then it seems as if a company could have 99% of their donations be legitimate and have 1% of their donations be problematic, and that under the one purpose test that they would be found to have violated the kickback statute. So doesn't this disincentivize companies from making the kinds of donations, that we want them to make? Like one
Your
trip up equals everything's bad.
Your concern is correct, Your Honor. However, by holding in favor of the relator here today, you would not diminish nor dissuade these entities from making these donations. What essentially the court would be asking these entities to do is to clean up the way in which they hold relationships with other entities. This court should seek to protect taxpayers from being defrauded by private companies such as SP and Duff. If Duff or SP were able to essentially contort their behavior as to apply under a safe harbor exception, they would not run afoul of the anti-kickback statute. So it's very clear that certain ways do exist that these relationships can continue as long as they are within the guidelines as published in the Federal Register, Your Honor. In conclusion, we pray this court affirm the decision of the 15th Circuit, as relator has successfully demonstrated that a genuine issue of material fact exists, or in the alternative, grant Mr. Simpson his day in court and allow him the opportunity to further demonstrate SP's wrongdoing. Thank you.
Thank you, counsel. Second counsel for the respondent.
Hello, Your Honor.
Good afternoon.
Chief Justice, may it please the court. My name is Logan Wallace, and I, along with my co-counsel, represent the relator, Mr. Bart Simpson. In my time before the court, I will establish that the 15th Circuit correctly granted summary judgment for the relator for two reasons. First, the relator sufficiently satisfied the causal connection requirement of the anti-kickback statute, and second, he made a valid claim under the False Claims Act. Your Honors, before I begin, I'd like to address a point made by opposing counsel, and that is to the motivations of Mr. Simpson. The motivations of Mr. Simpson are not relevant at this stage in the trial, nor should they be in consideration. The motivations in consideration should be those of Specialty Pharmacy, as they are the ones who committed the wrongdoing in this case. Additionally, the opposing counsel alleges that because Mr. Simpson was aware of possible fraudulent activities occurring from 2005 to 2017, he waited for 15 years in order to proceed with the most profitable position for himself, when in fact he was not aware of these actions by Duff until he was allowed to look into the possible financials in 2016 as he was asked to. It was at this point that he learned of the fraudulent activities with this quid pro quo arrangement with Duff, and then he proceeded with the QI-TEM action. QI-TEM actions are filed under seal and can take up to a year before they even have their first court appearance. So alleging that Mr. Simpson has sat on this action in order to make the most money for himself is far-fetched at best. Additionally, alleging that he's going to make $30 million is only because the fraud committed by Specialty Pharmacy was in the amount of $30 million. It's not that Mr. Simpson chose this amount, that is the amount that they have committed fraud in. Your Honors, this is not a case of a company donating out of their pure goodwill, but that of a company seeking to be as profitable as possible, no matter what it takes. In the wake of the Civil War, Congress passed the False Claims Act to curb the rampant fraud taking place in the Reconstruction-era South. And the modern-day application of the False Claims Act has shifted from post-war Reconstruction fraud to reclaiming funds obtained through a variety of other fraudulent means. And since the False Claims Act was strengthened in 1968, the government has recovered more than $62 billion and recovered more than $3 billion in the last year alone. Of this $3 billion, $2.6 billion of it was attributed to healthcare fraud. and is the 10th year in a row that this healthcare fraud recovered has exceeded over $2 billion. To my first point, Your Honors, the Court of Appeals for the 15th Circuit correctly held that Mr. Simpson satisfied the causal connection requirement of the anti-kickback statute. In 2010, Congress amended the anti-kickback statute to allow for violations to be brought under the False Claims Act. The new language of the statute holds liable for penalties a claim that includes items or services resulting from a violation of this section constitutes a false or fraudulent claim. Congress has been silent as to its intent of what results from, as phrased in the statute, should be interpreted as, but requiring a but-for standard of causation or other similar test would be against Congress's intent of strengthening whistleblower actions, as the Third Circuit held in Greenfield versus Medco Health Solutions. In Greenfield, the court specifically found that the legislative history of the False Claims Act was to prevent legal challenges that sometimes defeat legitimate enforcement efforts. Opposing counsel argues that a higher standard would lessen the 660 KETAM actions that occurred last year. However, if these 662 actions were valid, then there's no logical reason to enact a heightened standard and reduce valid claims. An extended standard would allow for the Anti-Kickback Statute and False Claims Act to reach the broad swath of fraud and abuse that are currently present in the federal healthcare system today.
Counsel, I'd like to actually go back to something you said at the very beginning about Mr. Simpson and when he learned about learned that there was something possibly wrong going on at SB. Where in the record does it say when he learned that?
Your Honor, I believe it is on page 6 of the record that
Okay.
he became, or he was aware of during his employment from 2005 to 2017 of fraudulent activities. But then it can be inferred from the record that he learned of the donations to Duff from 2012 and the exact details of its fraudulent extent from the market valuation he was asked to do.
How do we infer that from the record? What in the record would make us lead to that inference?
Your Honor, based on the record mostly from page 6 and 3, I believe, it can be read that Mr. Simpson was aware there was some degree of fraud occurring at Specialty Pharmacy. However, he did not have enough information about it. Then in 2016, when he was asked to do the market valuation and to engage in a conversation about how their market position would be affected if their donations were lessened, that was when he looked more into the financials and was given more access. Therefore, he had the information that could be brought as a valid claim.
Why is his conclusion about a quid pro quo worthy of summary judgment as opposed to sending this case to the jury?
Your Honor, his conclusion about a quid pro quo is very reminiscent of other claims that have been brought in the past year alone. In the past year, there were 6 claims brought in KETAM actions against pharmaceutical companies who used charitable intermediaries as a way to funnel money into paying the copays of their beneficiaries. And this was found in the Department of Justice's annual KETAM actions in summary. And these 6 companies or drug manufacturers had alluded to more than $600 million that they had regained from payments from the federal government. This is a synonymous case almost entirely in this situation. Alleging that the case has to go to trial would, at this point, waste the taxpayers' money and time. However, if it did go to trial, then Mr. Simpson would still come out on top.
What's wrong with requiring proof that there's a direct link between these 24 patients and the quid pro quo relationship, these 24 referrals?
Your Honor, requiring proof at this stage in the trial would be an unsuitable burden for almost any relator to overcome, as even if the case did go to trial, then each of the 24 individuals could be deposed and asked about what did happen, if they were exposed to it, or such and such, and from then on. However, disallowing entirely even that, as that's not the preferred conclusion to the case, even preventing that from happening would be a disservice to all of those who are harmed, especially the government, from companies such as Specialty Pharmacy. Opposing counsel erroneously relies on Clausen and Quinn to assert that the precise details of claims should be required. And the facts of Clausen and Quinn are fundamentally different than the facts in this case, because in this case, Specialty Pharmacy filled out forms 855S and 1500, to which compliance with the anti-kickback statute is required. In Quinn, excuse me, Your Honor, in Quinn, the relator was not able to point to a single instance in which the same medication was subjected to 2 claims that the relator alleged in the medication reselling scheme. Additionally, in Clausen, the court held the defendant was unable to provide any factual basis that the company was in fact overbilling. In the event that, to my second point, Your Honor, Specialty Pharmacy's reimbursement claims clearly violate a False Claim Act, because when Specialty Pharmacy submitted its reimbursement claims to the government, Specialty Pharmacy certified with all conditions of payment as mandated by the government. Certifying compliance with these forms holds Specialty Pharmacy liable under the false certification theory, as held in United States Health Services versus Escobar. In that case, this court held that the implied false certification theory can be a basis for False Claims Act liability when the defendant submits a claim while making specific recommendations or representations about the goods or services provided, but knowingly fails to disclose noncompliance with material statutory, regulatory, or contractual requirements. In Escobar, the court held that a person acts knowingly when they have actual knowledge, act in deliberate ignorance, or act in reckless disregard of the information at hand. This court also held that it is not necessary to prove that the person or entity had specific intent to defraud the government.
What about in this case, your opposing counsel argues that this wasn't knowing on their client's part. What is your response to that?
Your Honor, in this case, the knowing standard can be met by reckless disregard or deliberate ignorance. It would be very difficult to have a scenario in which a drug manufacturer or other Medicare or medical production company is giving money to another company and is then in turn getting a form of reimbursement or through patients and not thinking that there's something wrong about the scenario.
But what about the fact that there were other companies that people could have gone to, right? Other providers that were listed on the website. So SP wasn't the only one, they had choices.
Your Honor, they did have choices. However, there's no way to know at this stage in the trial that they weren't directed to Specialty Pharmacy in this case.
Well, there's no way to know that they were either, right?
Correct. You are correct about this point. The standard here in this case is that Specialty Pharmacy knows what they were doing. It does not matter if there were 4 others on this list with them. There could be 1 other, there could be 10 others on the list, but they knew what they were doing and being put on this list. And they knew that the list would have the certain effect in that they would get some patients back in recompense for their donations. When a Medicare beneficiary obtains a prescription covered by Medicare, they are often required to make a partial payment. It's usually in the form of what we know today as a copay. Now, Congress's intent in requiring copays was in part to serve as a check on healthcare costs in the United States. When a drug manufacturer facilitates for a copay of a drug to be paid by a third party, the company can then in turn charge the government whatever it is they see fit, because there would be no restriction on who, as a patient, would seek their services. If a drug could cost $1,500 and the next generic could cost $100, but if the copay is paid, then the patient sees no difference. They could have either one go and Medicare will cover both of them. So allowing special companies like Specialty Pharmacy to facilitate the payments of copays would further the multi-billion-dollar healthcare fraud scheme that's currently in place in the United States today. Additionally, allowing companies like Specialty Pharmacy to enact a heightened standard, as they're arguing for in this case, would do nothing to further the whistleblower actions or strengthen the whistleblower actions as Congress has intended the entire time with the Anti-Kickback Statute and False Claims Act amendments. These these statutes and cases exist to bring those to justice who defraud the government. And in this case, that is what we have. Specialty pharmacy is acting in a way that defrauds the government, whether they are acting with direct knowledge or deliberate ignorance or reckless disregard. They are still defrauding the government. And that is the scenario that we have to remedy today. Enacting a heightened conclusion would do nothing to remedy this and would in fact hurt the whistleblowers across the nation and encourage other companies such as Specialty Pharmacy to further defraud the government, as holding the standard that the realtor has presented in this case would be untenable. It would make it so though any company could not know just by stating they weren't aware that they defrauded the government or were acting in such a way, and it would allow them to charge the government whatever they saw fit, and they could make as much money as they ever dreamed.
Does not adopting the but-for test encourage sort of, I guess, frivolous qui tam actions? Encourage people, employees of companies, to file claims like this in order to try to, that are not based on anything, in order to try to get large sums of money?
No, Your Honor. There seems to be some misconception by opposing counsel that qui tam actions are just another action to file in court. However, there are an extended amount of work that goes into a qui tam action. The government can take a backseat role, such as they did in this case, and it requires more work on the behalf of the realtor. And when that happens, the realtor does all of the footwork against the attorneys of this multi-million-dollar corporation. It's not an action that someone's just going to frivolously file and then immediately move for summary judgment because they think it's a quick buck. It takes numerous amounts of resources and an even longer amount of time.
Is your presumption that if the government doesn't intervene and take over all of that hard work you're talking about, that's not going to happen in cases that have perhaps less merit on their face?
No, Your Honor. There's no way of knowing why the government did take a lesser role in this case. It could be due to less resources available to them in this region or any. I see my time is up, Your Honor.
Thank you, counsel. A rebuttal from the petitioner?
Chief Justice, Justices, may it please the court. 2 points on rebuttal, Your Honors. Although opposing counsel claims that SP must have been acting in bad faith because SP was aware that Duff used the donations for copays in the past, that is simply not the case, and there is no proof to substantiate that claim. Once SP made the donations to Duff, they had no control over Duff chose to utilize it, and Duff may choose to use it in a different way moving forward. That is simply Duff's decision and Duff's decision alone. Further, SP simply having their name on a list does not constitute a referral as the respondent suggested, because patients could choose to go to any provider that they saw as their best option, not simply SP or any of the 4 other corporations on the list. As to my second point, respondent cites to how much money has been recovered in fraud cases over the past years, but requiring a causal connection requirement will not defeat legitimate enforcement efforts. Instead, it would allow the court's resources to be applied to cases of actual fraud, unlike here. It would be a violation of separations of power for this court to step into the shoes of Congress and amend the AKS's causal connection requirement. Instead, this court should set a clear standard consistent with the AKS.
So I have a question. Your statement about the record indicating that the beneficiaries could go, patients could go anywhere to receive their services. They didn't have to actually go to the people that were listed on the website. But
Yes, Your Honor.
Aren't the undisputed facts that Duff stated, these are our approved providers and they're going to give you the best care possible? And there's language, there's long quotes in the record about that. I mean, isn't that essentially saying you really should go to these providers?
Your Honor,
How
I
is
see my
that
time has
different?
expired.
I'm sorry?
I see my time has expired. May I answer your question?
Yes, please.
Thank you, Your Honor. those were simply opinions of Duff and who they viewed as being the best providers within the area and going to give the most care. It was not necessarily a situation where they had to go to those specific vendors. And as I mentioned, there's also nowhere in the record does it state that any of the 24 patients that were party to, or I'm sorry, not party to the suit, but that the respondent brought forth, that they had any knowledge that those that list even existed, let alone that they received it or saw it. Therefore, for the foregoing reasons, SP requests this court to reverse the decision of the 15th Circuit. Thank you very much.
Thank you,
Thank
counsel.
you.
We'll take the matter under advisement.
With that, we'd like to thank our judges, Judge Herndon and Judge Taylor, for their questions and their attention today, and as well as congratulate our advocates on all of them on a job well done. At this point, I'm going to end the live stream and thank our audience for joining us today.